So good evening, good afternoon, good evening, everyone. I am the same Cristina Caffara as yesterday. Having watched myself on the website, I have decided I'm going to spend the day sitting on my hands because the amount of hand fluttering in that video was disconcerting. But you can't take Italy out of the Italian, so I literally sit on my hands right now. So I will omit the disclosure. Steve, it was a disclosure, not a credential brag. But I will, because I did it yesterday. So this is the last panel of the day. Let's try and keep it lively. Of course, we heard already a number of ideas and points, and I'm looking forward to hearing what the panelists have got to say. I have to say also that using my prerogative as chair, I've also kind of couldn't resist putting my own thoughts in writing, and I've sent them around to a few people ahead of this day, but they've not made it to the website. They will be there next week if Brooke can bear to edit it, but there it'll be. So what I intend to do is simply to pass the ball along the table without making lengthy presentations because they're boring. And you know who everybody is. I will then ask a few questions, but I'd also like to ask the panelists, if they may, to, in their presentation already, just take into account some of the things they heard in the previous panels, and if you feel like it, to comment on them or bring them in, because we won't have that much time for discussion at the end. My other instruction is please, please, please do not come up with the kind of comment we heard repeatedly many times, which I think is getting to be a bit grating, which is the idea that, oh, if you have these other goals, the legislator cannot take them in, no, the regulator or the agency or the judge cannot take them into account because they're outside of antitrust. I think the whole idea, and I will push it further in the panel, when you're thinking about a presumption like Tommaso does, is that ab initio, the setting of that presumption takes into account a concentration, incorporates certain concern, and in setting that presumption, the legislator or who may be will opine on where that threshold should be set. So I keep hearing this throughout the day, and we push it back, and it comes back, and so it's not what anyone, I think, is really saying. But with that, I want to start with Andrew. Andrew, please, of course, Howard University, we've seen your paper, but please give us the main points.
Okay. Thank you. Thank you to the organizers. It's a pleasure to be here. And thank you for those of you who have stayed. It's quite exciting for us. We thought we'd have a 1-to-1 ratio at this hour. My paper is called Locating Competitive Process Claims in the Consumer Welfare Debate. The focus is on non-merger conduct, and this paper has been posted on ProMarket, so I'm just going to summarize some of the key points in the paper. The first one is that we ought not allow the debate about terminology and standards to obscure what I think is a well-established line of authority that could be used to build out the law of what I am labeling competitive process claims. So I'm not using competition and or competitive process. I'm focusing on competitive process claims. Second, to illustrate that, I focus on one form of competitive process claim. It's especially well developed in the case law, restraints on the free flow of marketplace information. There's a very good, well-established line of cases that shows that in these cases, harm to competition is highly likely. In other words, impairment of the competitive process was the anti-competitive mechanism of competitive harm. It's not some alternative to showing competitive harm. Third, in many of these cases, the immediately harmed parties were trading partners, not end consumers. I think the discussion about consumer welfare has created a caricature that it only cares about consumers in some kind of end consumer retail model. Not true in some of these cases. They involve trading partners. I'll talk about very briefly National Society of Professional Engineers. You and I generally don't purchase engineering services. People who are funding buildings and making other projects do. Are they consumers? The point is that the law has been far more adaptable than that kind of critique imagines. Fourth, and importantly, These decisions have relied on reasonable inferences, assessments of probability, and presumptions. Neither market definition nor evidence of actual effects is typically required or demanded, and the restraints have arisen in both Section 1 and Section 2 cases because they facilitated collusion, resulted in exclusion, or some combination of both. They're not limited to horizontal conduct. And finally, these information-focused claims likely do not exhaust the possible range of valid competitive process claims. Rather, my hope is that by bringing them into greater focus, they'll invite further consideration of conduct with similar anti-competitive tendencies that might also warrant reliance on stronger presumptions of competitive harm. In the interest of time, I won't go through the cases. They're all described in the post. I talk about National Society of Professional Engineers, Indiana Federation of Dentists, but then later cases that build on them, Polygram Holding, Real Comp, which I think is a case worthy of more attention than it gets. In the unilateral conduct area, the Microsoft claim that focused on deception in connection with Java development. And finally, there's an allegation still pending in the Epic versus Apple case about Apple's process, their practice of limiting access to information about alternative payment methods. In all of these cases, what you're going to find is that the anti-competitive conduct was directed at limiting information that facilitated competition. And in limiting that information, the probability of harm to competition was highly likely because it distorted competition, diverted business, or otherwise was likely to harm competition, not only about price, but often about innovation, knowledge of new business models, and access to new forms of competition, which eventually impedes innovation as well. That's
Just a quick follow-up question. This is taking up a particular aspect of what you think is problematic in conduct. How do you relate this to the kind of exam question, which is what should we replace consumer welfare with?
Well, as I start the paper, I say that it's an interesting debate about linguistics, but I don't really think that the choice of standard would change these cases. These are not... And again, honestly, Christina, I think it's because consumer welfare has been created into a caricature. That's not really what it is. These are very straight-up cases in terms of impact on competition. They are not debating whether consumers are harmed. They're not debating is price going to go up. They are based on conduct that keeps competition from happening. That should not matter, depending upon this debate about standards.
So your point is really that it's not really what the standard is, but you are interested in the tools.
I'm interested in the tools and not making easy cases hard. And the choice of standard can take an easy case, and I think this is, as a group, easy cases and make them hard.
Great. Let me move on. Barak, what would you like to tell us?
So the title of my piece is It's Okay to Ask for Help. I think the three of us have one commonality, which is we're all talking to antitrust judges like they're in kindergarten. We're trying to keep things very simple. The premise of my piece is that there are a number of cases. It doesn't matter how you define the consumer welfare standard, or it doesn't even matter what kind of economics you're talking about. There are just some very profound mistakes that are made by judges that I argue could have been avoided if judges enlisted some help from economists. So the subtitle of the article is called The Antitrust Rooney Rule. The idea is to encourage or maybe require judges at least to interview an economist if they're going to appear or if they're going to hear an antitrust case. And the idea really is to try to encourage some kind of economic systematic thinking into judicial opinions, which too often we don't see really any of it at all. To the degree that there's anything that to be said about how I came to this, most of my antitrust work is in the healthcare space, where there is an extraordinary wealth of really bad antitrust opinions. A lot of the bad antitrust opinions are reflected in certain presumptions, factually incorrect presumptions about how the healthcare markets work, in particular the motivations and the business models behind healthcare providers. Most of these mistakes take place at the judicial level, the level of the district court. And to the degree that I'm trying to figure out how to come up with a least restrictive solution or intervention into the problem, it would be simply to try to enhance the capacity of the individual judges. I think maybe to some degree this reflects a little bit of inductive thinking. I tend to be an inductive thinker. I actually think that the best thinking in healthcare competition policy is inductive, trying to really understand the complexity of the marketplace and understand exactly what's going on. In many ways, I think that that certain presumptive models or even ideological models tend to offer a lot of confusion. And what this is trying to do is, at the very least, incorporate a mechanism where there can be a little bit more systematic thinking on the part of the judge, where the judge can be at least open to, very much with the spirit of the Rooney Rule. I'm not sure that actual Rooney Rule is working, but never mind that. Just trying to encourage an alternative framework to understanding the facts in front of the judge.
So you're advocating education for the judge by essentially appointing an economist to support him. Who appoints that economist? How does he choose him if he has no idea what economists are about? And second, we have examples in Europe, jurisdictions where the judge ultimately has a helper. It's not often that you find great results from that. But I mean, I will not resist the suggestion that a bit more economics with the judge is probably good.
Yeah, so two quick responses to that. One question that I got yesterday at the cocktail hour was, what kind of economist are you looking for? And my answer is really any economist. I think that the baseline is pretty low, to be honest. And it's, again, the key here, the mistake that we're trying to avoid is not a misinterpretation of a certain parameter in a regression. The mistake we're trying to avoid is fundamentally uneconomic thinking in these cases. And I have a couple examples in the piece. And I think that these examples are kind of, sadly, the norm in at least a lot of healthcare cases, especially hospital cases. And it's worth also saying that mistaken judicial opinions in hospital merger cases set back antitrust policy in the healthcare space about 20 years. The harm is really significant in these handful of mistakes, and the mistakes have been somewhat systematic.
Okay, let me move over to Bill. Bill, take it away.
Thank you, Christina, and thanks, Filippo and Luigi, for the great honor of being here. I'm going to take up Professor Caper's challenge to talk about how to do it. I'm going to speak about how an agency might go about applying a chosen set of goals. I'm not going to talk so much about what those ought to do, but I have views about how they should actually be applied in practice. And the key to effective implementation, in my mind, to make the choice of goals legitimate and accountable is meaningful disclosure by the agency. Here are the elements of what I regard to be good process in laying out goals and applying them. I think good practice dictates you begin the year with a clear statement of what your goals are, along with the strategy that you intend to use and the programs you have in mind to achieve them. The CMA in the United Kingdom has a good process for this. They have such a document. They begin with public consultations, so there is a debate at the very beginning of the year for the agency to identify what those goals are, who are the audiences, legislators, firms, NGOs, the larger public, all designed to identify what the prospective program is, the aims that motivate it, and to have a debate about that, and then to say, this is what we will do for the year ahead. The second element is to have a project selection process that, again, clearly identifies what the aims are and links specific programs to the accomplishment of those aims. The CMA, for example, has a category of priority called vulnerable consumers, vulnerable citizens, which uses the broad framework available to address the concerns of the economically disadvantaged, the socially disadvantaged. A good deal of the program is framed around that. And this selection of priorities should be accompanied by an imagined identification of what you're going to get if it works. That is, imagine that your program worked. How will it advance the objectives that you've identified before that you're pursuing? Is that a speculative exercise? I suppose so in some ways, but it wouldn't hurt to have at the beginning of the project a clear statement by the agency is, if things work, this is how our project will advance the goals that we've identified, again, to enable outsiders to keep score. The third is that this should be done with a degree of historical awareness. I'm struck in the discussion over the last 2 days of the epidemic ignorance about what agencies have actually done, especially those in the United States. When you take a look at the US program, going back through what Tim called the winter, the winter of no enforcement, there are a striking number of programs that don't fit and focus significantly on economic disadvantage and vulnerabilities. Let's think of a couple. I would look at the program that's been built to attack collusion in public procurement as being a striking example of a program that ticks many of the boxes in question. If you do a good job on this, and by the way, this is 17% of GDP in the United States, from federal down to local government, 17%. That's a big economy if you haven't been following it. What happens if you move the needle in the right direction? Well, you do get efficiency gains right away. Governments probably are able to buy more goods and services for the same amount of money. Second, most of what governments are buying, and by the way, the 17% is not, puts aside the defense acquisition side of things. They're buying essential social services for which people who have lots of money contract around. People who have lots of money send their kids to private schools. They take helicopters to where they ever want to go. They don't go on the bad roads. People with means contract around all of the public services that are the focal point for public procurement. If you deliver good results in your public procurement system, well, you're largely distributing benefits to the second half of the income distribution, including to many of the dispossessed who don't work, don't even have a place to live. Another thing you do is you attack corruption, which is endemic in many of the collusive schemes that operate against the interests of taxpayers and individual citizens more generally. If you do this, you probably increase the sense of civic trust and legitimacy. Individuals touch the procurement processes results every single day. They drive on the roads, they ride the transit system, their kids go to the schools, they have the lunches. They see whether or not this works or not. It's a daily test in their minds about whether government is performing worth a damn. If you improve performance, even by a small amount in that area, I'd say you have a huge residual spillover for democracy and trust in public institutions. So I think you want public procurement in the portfolio. It astonished me that our first moderator for our first panel on the first day referred to the concern about bid rigging and public procurement as being, well, an epithet. It seems to me that if you want to hit all of these goals, you've got to have that in the agenda. Similarly, I look at the remarkable extent to which the public budgets for the agencies are framed in terms of sectors such as healthcare, transport, energy, food. They're not talking about the yacht cartel. Of course not. They're focusing attention on core services and concerns that, again, I'd assert have major concerns for individual citizens. And I think of a case like the South Carolina State Board of Dentists case, which the FTC pursued in 2004. It's targeted to provide a low-cost fluoride treatment for kids in public school systems in South Carolina. The first page of the FTC opinion explains who are the main beneficiaries. African-American kids from poor families in South Carolina who otherwise are not going to have access to good dental health care. In short, if you look at what in detail agencies have done, I think you find a remarkable amount of activity that's focused on economic disadvantage. Maybe agencies should call that out more directly and link it to the larger aims. But this has been part of the program, so it's not a big jump to say that this might be a focal point of attention in a program of public enforcement. Another element is that when you write decisions, they ought to be informative. You ought to show your work. When agencies take decisions, spell out what motivated it. Don't shroud the goals or objectives that you're seeking to perform. Lay out all of the motivating aims, and this applies to courts as well. And especially where you have trade-offs. I mean, the famous passage in the Brown shoe case where the court talks about the possible benefits of vertical integration wraps up by saying Congress appreciated that occasional higher costs and prices might result from the maintenance of fragmented industries and markets. It resolved these competing considerations in favor of decentralization. We must give effect to that decision. You could raise your hand in the courtroom and say, how much by way of higher prices are you willing to pay? Let's look at a trade-off here. 20% more? Suppose that the price reduction was going to be dramatic. How much are you willing to pay if you're faced with a choice between those price reductions, output increases, and the benefits of decentralization here? If you're going to do the trade-offs, I think you have to explain what the exchange rate is. Not with apology. You can say we're doing what the legislature meant, but you can't hide the choices that you're making in doing this. And when tensions arise, you have to explain in a transparent way how you've resolved them. You wrap up the year with a report that talks about what you did and how what you did is linked to the goals that you set out at the beginning of the year that you said you were going to pursue. Yes, indeed, that is also published in a draft, so you have a public consultation in which people can comment about how well you did. Did you pursue the right goals? Did you go about picking projects to advance them effectively? And last, yes, you have a program of ex post evaluation, which asks the same questions. What were your stated objectives? How well did your projects advance those objectives? Lay out the objectives, lay out the projects that you had in mind. How, at the end of the projects, did you make progress in accomplishing these things? If you do these things, whatever your goals happen to be, you've made yourself far more accountable and legitimate. And the formative figure in many ways for this was Phil Arita. It wasn't Bork. Arita's the guy who said, yes, Congress had many things in mind. What do you do with the broad goals? Arita simply said, you ignore it. Why do you ignore it? You ignore it because it can't be applied effectively. Well, I think if you go about it in this process, you start to move in the direction of identifying ways in which to apply a framework that accomplishes those legislative objectives and others, and you're doing it in a way that makes it clear to outsiders what you're doing and how you're doing it.
Well, Bill, so I like the focus on goals, objectives, strategy, processes, the way you break it down and essentially saying I'm stepping aside from trying to define an alternative highfalutin alternative standard, okay? Because if you do these things, then you kind of accomplish things in practice rather than sort of talking in general. Now, a common feature of this panel is, in fact, that it has neatly ducked the question, which is, what are we going to replace that efficiency-based consumer welfare thing with very good reason, but it doesn't, none of you has offered a direct alternative, unlike the previous panel. So not so fast, we'll take you back there because I'd like you to express views on what you heard earlier today. So let me start with what I would, I think, fairly categorize as one side of the debate, which is the paper by Herb and Fiona, which is more in favor, I think it's fair to say, of the status quo, on the basis of the principle that price and output are things we can measure, and so at least we've got that. All those other things are much vaguer. But I think it was interesting that in the discussion, Herb, you said you acknowledged that even price and output, simpler as they may be, particularly output, are often difficult to measure, and you, as cardinal measures, and so you then say, well, we are interested in ordinal measure, directional. And my experience personally as an economist at the coalface, as I said many times, is that output changes even are really impossible to measure in any meaningful way. So because we make inferences from things that are not very interesting, like market shares or stuff like that. So how does this panel, each of you who want to comment, feel about the persistence of that idea? Is it something you still feel some warm feeling for attachment, or is it something that you agree we need to move on from?
Well, can I just say one thing? I do think that at least in the cases that I talk about, that's all a second-order question. I mean, the first-order question is just trying to get some kind of economic rationale, whatever your standard is, incorporated. We have some very foundational problems that we need to solve in these really important cases. So, talking about, much of the conferences talked about issues that are not of pressing importance in the healthcare sector. And by the way, Bill says that his sector is 17% of the economy. My sector is 19.5% of the economy, so I win. The other thing I will say is that, and I said this to Herb, I mean, in most hospital mergers, they increase labor, they increase hospital output, but they destroy the local economy. And I don't know how generalizable this observation is, but if what you care about is the standard is, does the acquisition expand output or not, that would pass Herb's test, but I think it would be disastrous for the economy. Now, I think that if we're talking about other standards, I think that Eric's standard on market power would probably be more appropriate. But again, I'd be a little worried about generalizing it across industries. I think one thing that's wonderful about economists is, especially economists in antitrust cases, is that they're very grounded with the market that's right in front of them. And they ask very particularistic questions. They force judges, they force litigators to go through a systematic analysis of what the particular transaction or conduct is going on. And that, I think, is the most important thing, more than having any kind of overarching theory.
Any comment?
Yeah, the vocabulary is bankrupt. It's worse than bankrupt. It's a distraction. If you mention it, you've got to be ready to drop the gloves and start fighting right away, because people go for each other's throats without even defining terms. What do you mean? What's encompassed by it? It's such a barrier to effective communication now. So I would say that, yes, within the meaning of the statute, protect competition. Someone asks, what do you mean by that? All right. I go through the list of the considerations we've been talking. Output, as Herb defined it, price, quality, innovation. That's on the list. I'm concerned with distributional effects as well, at least as a prioritization principle. If I have a choice in deciding what my program is going to be, I'm going to say, I'm going to give major emphasis in my program to people who have fewer means for two reasons. One is, arguably, they're the ones who need it the most. But second, I have to build political support for my program. I have to sit in front of legislators and explain what I'm doing. I'm not going to sit there and talk about my indifference to their needs. I can debate one by one whether or not the specific objectives that are being urged upon me, sustainability, climate, others, are things that I think I can handle. But I have distributional concerns clearly in focus, which is why I'm fond of the procurement agenda. But whatever I do, whatever those are, and that's how I would have laid them out, I explain what I'm doing every year and saying, these are the ones. And by the way, these are the cases, the advocacy programs, the programs to try to knock down in the whole of government theory going back decades, artificial barriers to access to the market. These are all the things I'm doing to accomplish these objectives. And I'd tell my larger audience, if you've got a better idea, I'm listening. But these are my aims.
Andrew, do you have any comment?
Yeah, what I'd like to add, and we really haven't discussed it in these 2 days, is to put this issue of the consumer welfare standard into some larger historical context. Clearly, antitrust began to change in this country by the late 1970s. It was actually before the Reagan Revolution. It was before the Reagan Revolution brought different leaders to the agencies, different judges to the courts. It started to change because of 4 appointments to the Supreme Court by Richard Nixon, and then a 5th by Gerald Ford. And so when the Reaganites arrived in Washington, they had a Supreme Court that was very receptive to something, and Frank Easterbrook referred to it last night. The literature of Chicago had been developing for 40 years, but they hadn't hit a moment like that where politics and power aligned along with a Supreme Court that was receptive, and that facilitated some very significant change. It didn't mean that they won all of their battles. It didn't mean that Bork got the consumer welfare standard that he envisioned, that he wanted. Baxter and Monsanto wanted to change the per se rule against Dr. Miles, and a Democratic Congress yanked his chain and pulled his funding and said, you're not going to argue that before the Supreme Court. My point is this, is that it makes no sense to sort of single out this one piece of change, this standard, without thinking about the larger context in which it arose and the larger context in which things began to change. Now, this could be depressing to today's reformers to think about, gee, Director and Levy, they wrote their first article in 1947. Do I have to wait 40 years for change to happen? Reformers always want change to happen more quickly than that. I think the big question for today's debate for these 2 days is, are we at a moment that is receptive to this kind of change? Is the political power there? Well, to some degree, we've talked about it. Yes, the political power is there. But it's pretty shaky political power. It's not uniform political power between the two branches of Congress. I'd venture to guess we have a Supreme Court that's a little bit unpredictable on antitrust. Yes, they rule strongly for the plaintiff in the Alston case, but man, that is about the most anti-plaintiff, pro-plaintiff decision you can read. It is dripping with all kinds of statements pulled from other cases like Trinco, skepticism about antitrust, skepticism about private cases, and that's what defense bar lawyers are going to cite in case after case. I was talking to Christina yesterday about what was missing from the panel that was bashing junk economics. Junk lawyering was missing from that panel. But you know what? Junk lawyering is well armed right now because of years of Supreme Court cases that embrace presumptions, that embrace arguments, that have armed burden of production, Twombly. Oh, you got to be plausible. It's not just about conspiracy. It's got to be plausible market definition. You got to have plausible market power. You have to have and what does plausibility mean? It means what a judge sort of judges to be plausible, and then you don't get past pleading. Summary judgment, burden of production. Well, that's very high. You have to go well beyond. Now your evidence has to be plausible. So the combination of procedural changes, political changes, judicial changes have all led to why we're all here debating the current state of antitrust. And unless we really think about the broader context, we can sort of blow as much smoke as we want, that's the nice way of saying it, about, gee, what should the standard be? But I think Christina used the phrase, somebody used the phrase, when the rubber hits the road. How are we going to advocate these things? Who's going to be listening? And what kind of changes can we make that can be effective? Steve Salve's paper lists lots of different types of articles. He notes lots of changes that have happened during this period of retrenchment. It has not all been one direction. There have been plaintiffs' victories. There have been important cases that plant seeds that can be used. That was partly why I wrote my paper. It lists a whole line of cases that are plaintiffs' victories, that lay out theories and possibilities for relatively easy probabilistic wins. We have to, at the same time we're challenging the big ideas, we can't lose sight of the battles we can win by using the tools we have available.
Christina, can I add one point to Andy's discussion of context? I think it's very valuable in seeing the development of the program over time and doctrine to consider the forces that drove it. I loved Carl's presentation where he said, let's look at specific examples and see what we think of them. A case that was a real hinge for this, that introduces competition, not competitors, more directly into the field of vision is Brunswick in 1977, where the plaintiff's claim for damages basically was monopoly profits minus the profits that would be gained with having a second rival in the market. And the Supreme Court scratched its head and said, that can't be right. Unanimously said, no, it's a Thurgood Marshall opinion, and that is the modern instance in which the court uses the famous phrase, competition, not competitors. It's happening at a time when the US economy is stagnant. We're running in the direction of 20% inflation, 20% interest rates. The literature is filled with documents that say the US has lost its edge. The future is in Asia and in Europe. We're not going to be able to perform effectively. So how is it that efficiency comes into view? It's in that context. The most powerful declarations of the egalitarian vision of competition law appear in my view, it's Alcoa, it's certainly Brown Shoe, to take the two pillars. When are they done? It's when the United States has no economic rivals in the world. So in Brown Shoe, it's possible to imagine the court saying, are we willing to pay a little bit more for the sake of having this fragmented set of industries? Of course, we can afford it. Nobody talks that way after the crisis in the economic system begins to develop in the 1970s, which means that these goals are going to change again. This is a malleable system, and it depends a lot on this context.
I want to. Carl mentioned in his remarks the Utah Pie case, and Bill just mentioned Brunswick. If Brunswick had been before Utah Pie would have been dismissed for lack of antitrust standing, for the same reasoning that the court reached in Brunswick. If I can add one more thing, I thought this was very ironic, maybe entertaining, but Frank Easterbrook last night mentioned his article, Limits of Antitrust. It's amazing how that article has continued to influence and frame the debate. One of his big points is that judges don't know what they're doing. That was one of his points in that article. Juries certainly don't know what they're doing. So he reasoned from that mistakes are likely, and that built his argument that false positives are going to, and he repeated it last night, they're going to get embedded, they're going to be hard to reverse. And so from judicial lack of competence, he reasoned to very permissive rules because of fear of error. And over 2 days, I've heard extraordinary agreement that judges lack expertise and competence. So we have this great agreement, except it's led to an argument for a return to brighter presumptions, bright line rules. That's exactly what Chicago was responding to when the Limits of Antitrust was written. We've had this over-deterrent system of per se rules. So here we are, we've come around, and I think we need to do better than sort of going back to the kind of bright line per se rules that existed. Not all of them were really good ideas, but we can do better today with presumptions, maybe with some revised and informed per se type rules. But it's important to realize that we actually have to have some faith in the rule of law. We can't toss that term around and say at the same time, judges don't know what they're doing. Judges are going to have to decide these cases. And if you believe in rule of law, you have to believe to some degree in the judicial system. An attack on judges and judicial expertise is sort of over and over, you are saying you do not believe in rule of law. And antitrust is not any more complex than securities, environmental, complex criminal conspiracy cases. We do ask our federal judges to do a lot of different kinds of cases. But this notion that antitrust exceptionalism, that somehow, we're in an area that's really hard to understand, ignores the reality of the larger judicial system. Sorry.
Well,
but I don't feel strongly about anything.
No, not at all. And junk lawyering, I am very familiar with that. It's just enough for me to be rude to my own side without being rude to the lawyers too. But I mean, so much content here. And of course, you talk about the context, which is very much what in some way drives what, for example, Tommaso is talking about when he talks about rebuttable presumptions. I mean, and what Eric implicitly talks about, because to your point, we have the pendulum has swung. We have come all the way out of the Chicago cycle, which resisted presumptions before, because the view now is we are in an environment in which there is a sentiment. I mean, Tommaso said, I'm not happy with where things are, so we need to do something. And so this something cannot be more of the same, more of this exceptionalism, more of this complication. One thing to think about is this notion of some bright rules, some presumptions. And so you mentioned that you're not against them in principle. The question is going to be how does one structure them? But would you like to elaborate, all of you, on this idea and how warm you feel towards it?
Yeah, I'll take a swing at the pitch on merger control. You could say that the presumptions over time have become significantly weaker. Look where Bill Baxter's guidelines sought to draw the line. And in a rough sense, on coordinated effects, those were designed to stop 6 to 5. And the agencies fought that battle in a number of instances in the 80s. They fought it even above the threshold. So we've had a drift away from that vision in a number of ways. how do you restore the frontier that at least was set at that point to make the presumption more robust? This is where the research agenda, I think, is very important. In the field that Barack knows much better than I do, the effort to restore effective merger enforcement in the hospital domain based on better empirics drew upon a research program that suggested that the assumptions courts were using routinely were badly out of line. Now, sadly, that took a while to build the research. With it in hand, the FTC was able to go back into court more often and have successful results. And I'm simply wondering whether, do we have enough evidence before us? Can we marshal that evidence? So we think about a strategy, sector by sector, to go into court and say, document the drift. That is, this is how the perimeter is narrowed. And the inner fortress is all that's being defended at 3-2, 2-1. This is where it used to be. This is why we have to go back out to the earlier frontier, especially for coordinated effects, where the really interesting research on cartelization now shows that you can run really effective cartels with 6 or more members. To build that empirical case, I think if we ask, how do we get back out to the presumptions where they were in the 80s? Part of the answer is you build the evidence, you assemble it, go to the courts and say, this is what we know about the effects. This is the drift. Here's the restoration.
I'd add to that in the following way. I mean, antitrust is law, and in that sense, there is the reliance on presumptions and analogies, and we see all the weaknesses of that epistemological approach in antitrust cases. The analogies are misapplied. The models are a little bit too coarse. I think that the story that Bill is telling about the FTC having to go back and do its homework is both a victory story in the sense that they didn't really develop presumptions. They just developed some really good empirical methods. The sad part of the story is that they had pretty good empirical methods beforehand, too. They got better, but the earlier methods just weren't working. And they weren't working not because there were better methods out there. They weren't working because there were certain presumptions, certain legal analogies, certain twists of words and semantics that judges were using to get to the wrong outcome. So, I mean, to the degree that it was lawyering that got us into this problem, I worry that presumptions are just another kind of lawyering.
Andrew?
It is another way of lawyering. It is, but let's separate out competition policy. This is something that has been discussed over the 2 days. Law enforcement is just one type of competition policy. Law enforcement is case by case, and it is law enforcement. So it's subject to the same framing, the same system, using burden of pleading and production and proof, and presumptions are traditional things that we use in the law. None of that is unique to antitrust. The role of experts. It's especially important in antitrust, but the rules for experts, including court-appointed experts, apply to all cases. Class actions. The Supreme Court has shown its great hostility to class actions, which has really affected private enforcement, which, again, we haven't really talked about for the conference, but private enforcement needs help, and the agencies could be helping it. So it's not that in lieu of, because there's barriers to law enforcement, that you drop it, but you do think more broadly about tools, and I think the agencies are doing that. The whole of government effort is about competition advocacy across the government. The FTC's efforts on rulemaking, I don't know if they have the authority. We can put that debate off for another day, but that's an example of trying to expand the tools that are available beyond case-by-case law enforcement. So I think part of the answer, Christina, is that, and the word tools has been used in Europe even longer than here, is you have to consider the broader range of tools. Right now, the hope that Congress was going to create more tools doesn't seem very likely, so you work with the tools that you have, and creatively. And
exactly, you have to stretch the tools.
You have to stretch the tools. Yes. I'm working on a short paper about the importance of, I'll do hanging quotations. I don't like them very often. I'll do it right now. Small monopolization cases. The history of antitrust is full of small monopolization cases that really came up with very useful principles. Lorraine Journal is just a classic example. What are the chances the lawyers who litigated Lorraine Journal in 1951 thought we'd still be talking about that case? But you think about that case, it's fascinating. New technology, AM radio, is challenging the incumbent, the monopolist newspaper. I'll bet there's a lot of newspapers that wish they could still say that about themselves.
Both two-sided markets.
Both two-sided markets. A weakness, a vulnerability, advertising. And you look at that case, and it has lots of very current themes, raising rivals' costs, reducing rivals' revenues, and that case lives on. Well, that case didn't take 10 years to litigate. It didn't involve the largest impact on the economy, but it's a building block. There are some cases like that that are pending before the agencies now. Dentsply is another good example, not the largest case ever brought, but Dentsply is an important Justice Department case that established some useful principles about exclusive dealing. And I won't say anything like it was pulling teeth to get it through.
We've
I wouldn't say that.
When you look at the history of different agencies and the U.S. agencies, you have programs that show how you can carry out extensions, how you can restore frontiers. And they involve a good awareness of where you are, how you got there, a willingness to take chances, creativity at the margin. And I think what we lose in our system so often, for a couple of reasons, is an awareness of how that took place. So that if we're thinking, how do we get back to the summit in some of these areas, there's a way to climb. But you forget how you got up there. You don't know what the path is. You're not willing to listen to guides who went up before. And if you marshal that kind of know-how, there's a way to get back. But there are these kinds of techniques and methods. Other organizations study them pretty carefully to advance by learning. What a surprise. If you study those episodes, I think there's a lot there to suggest how, within any framework you want, how you reset the boundaries in a direction that is more compatible with the larger objective of the system, but also accounts for these emerging developments that you were referring to yesterday in talking about ecosystems.
So, in fact, at my conference last month, I had a panel on new law, new posture. I think a lot has to do with posture rather than necessarily new law. Now, I saw Eric leave, and it's a pity because I wanted all of you to comment on his margin proposal, but also, we can do, but also in the interest of time, I was wondering whether I can open it up to the floor and for people to comment so as not to monopolize. So David,
We wouldn't want to do that.
David has got a question.
I don't want to pick on Barack, but
Yeah.
I'm going to pick on Barack. First of all, I mean, the Rooney Rule just manifestly does not work. You look at the Brian Flores case, he's suing the NFL because he was fired for winning. I feel like just as you're not going to cure racism by taking a meeting, you're not going to cure the failings of precedents with a tutor. And the other point, and I mean that's a minor point, but the other point I want to make is that we actually did this. In 1976, the George Mason Law and Economics Center started a 2-week, all-expense-paid conference where up to 40% of federal judges went annually. They did it for 23 years, and a 2018 paper showed that it had a marked and quantifiable effect on future rulings. Judges were more likely to vote against the National Labor Relations Board, they were more likely to vote against the Environmental Protection Agency, and their criminal sentences got longer because they were exposed to this line of reasoning. So there are some of us in this room and much more of us outside this room that think that creeping economism is actually the problem. And particularly where the biases come in through that. I should also mention that about 105 corporations funded the Law and Economics Center conferences that went out there. So I thought that was something to bring to the table.
Yeah, no, I'm not sure that article establishes causation. I think that there's a significant selection effect on judicial appointments that Andy was talking about. But more seriously, look, I do believe that judges are people who want to get the right answer, who are pressed for time, and who, just from a purely cognitive perspective, rush to judgment based on heuristics. And that's the cognitive mechanism that I'm targeting. I have a paragraph in my piece that acknowledges the severe shortcomings of the Rooney Rule, not just about the Brian Flores story, but some other more systematic studies. I have another paragraph distinguishing the failure of that rule with the possibility of this rule working. To be brutally honest, I put in the Rooney Rule as a catchy thing. I mean, look, these are Article 3 people, and I think it's a very, look, and
that's a far more publishable title.
Article 3.
How to convince the unconvincible. I mean, no, and I don't think this is a capture story. I think this is one about ideological heuristics that are reversible. That's what I think.
David, I want to know if any of those judges disclosed their trips. Never mind.
There's a question over here.
Interesting.
Thank you. So I have a question for Bill. I don't know. So when I hear you, I'm hearing basically a descriptive account of what agencies are actually doing, maybe more in the UK than in the US, but it's actually happening, right? And so normatively, I'm seeing your paper as an argument for, so your question, or the question that we should ask maybe is, who should be defining the goals of antitrust? Is it courts? Is it agencies? Is it another branch of government? Or, is it Congress? And I see actually the three of you engaging with that question. So, some of you are more interested in giving the power or the prerogative of determining the consumer welfare standard or goals of antitrust to courts, and others less. So maybe you want to all comment on this, but it's specifically for Bill.
Yeah, I see in the first instance it's the agency that's going to be the catalyst through the kind of disclosure I mentioned, by, in a clear and non-apologetic way, saying this is what our program is, this is why we're doing it, this is what we see to be the whole point of our enforcement program. These other audiences will see that. If Congress doesn't like it, there is plenty they can do about that. They can bring you up for hearings. They can conduct investigations. They can say, that makes a lot of sense. We like that. We don't regularly come back and do a restatement of the law. Maybe they should every, say, 100 years. This is what we said in 1890. We still believe it. This is what we said in 1950. We still believe it now. To have that process, basically, of renewal. But one major audience is the Congress in this process, with the agency being a catalyst. And indeed, it's the courts as well. It's the courts with the agencies guiding, backed by this research capability, backed by the analytical approach, and backed by the legitimacy that comes with using a process that distills a program that I think is faithful to the conception of the statute, to modern social needs in many respects, and the court's in a position to judge using their interpretative authority to decide where to go. But it's the agency that sets it in motion with honest, full disclosure. But maybe the main audience is ultimately the Congress, which has to, every year in the US, has to pay the bills for you.
I'll just say briefly, I'm a big fan of Bill's paper for the same reason I'm a pretty big fan, although less so, of my paper. I mean, I think that Bill's approach, it enhances transparency, it enhances accountability, but I also think it's a disciplinary device. I mean, if you say what's important, you're more likely to follow what you think is important. So I think it's actually a very effective way of focusing priorities on an agency. I mean, focusing an agency's priorities.
I mean, for example, there's no question that the FTC brought the South Carolina State Board of Dentists case in many respects because of the target victim audience there. No doubt about it. And in a move of transparency, Commissioner Thompson's opinion for the commission on the front page lays out the facts. It's impossible to read that page without getting a sense of why this case is here and not some other case. Now, the agency might have done a lot more to say that economic disadvantage in this sense is a major prioritization principle, and to describe other matters that were consistent with that. That could have been done more fully, but that's an example of how the agency, I think, is a catalyst. Part of the audience was the Congress. Part of the audience ultimately was the Fourth Circuit Court of Appeals.
So let me give the last 1 minute to Andrew for a final comment that he may have, and then we need to really go to Luigi for the wrap-up.
Let's not let the debate over standards obscure the useful cases and useful principles that really don't rely on that debate about standards.
Well, that was less than
Well
a minute,
done.
but I think it's well done. Oh, you want to ask a question? Okay, then quick.
Two quick questions. One question for Andy. So I read your paper and I mostly see you saying there's a lot of like cases we could be winning in the current, even under the current standards they were not taking. But most of the cases you cite are either quick look cases or Microsoft. So do you, and I think Microsoft might come out very differently after Trinco. So I wonder if you think these are winnable cases. And for Bill, just to finish, so in a way your proposal is very much less bold than I would have imagined, because you're mostly asking the agencies to grade their own homework. You know, they have to produce their own reports, do everything. Well, something that's interesting is to notice that the US antitrust agencies are probably the most opaque agencies anywhere in the world. We discovered this because we actually filed a FOIA about something relating to mergers, and I didn't know, but everything that relates Hart-Scott-Rodino is FOIA exempt. You cannot ask a single information. Or in other countries, actually, when you file a merger, you have to publish a notice of merger. This happens in Brazil. In Brazil, for example, because you're concerned about potential conflicts of interest in the agency, everything that happens in the agency is public. You have to file public reports. You have a case. You have to have public versions of the opinions, which are also redacted for confidential information, but you know what's going on at the agency. So don't you think you're giving the agency too much leeway to grade their own homework? I think this was fascinating.
Not if they're really great instructors, you know, and can do a good job of that. I think they're, for starters, if you have a process where you are doing more complete, honest disclosure, then you have a better informed debate. Second, I think there's a role for external review too. That is to have in effect an audit, an academic audit perhaps, where you bring in outsiders subject to some confidentiality requirements, but let them report on the results. And last, I think there are good disclosure habits that can be replicated. John Quokka's talk that kicked this off, that data set he had on his slide, 1996 to 2011, guess who decided to form that program and put that data set out? You know what kind of opposition there was inside the building? Death threats? I mean, having other people taste my food? The reaction was, if we deconstruct all of this information and explain what the decisive factors are, then they'll know what we did. Yes, they will. And Malcolm Coate, God bless him, did the painstaking job of going through and extracting this information. That's something we did and ran basically from 2005 up through 2011, and it is a shame that was discontinued. That's worth doing not just at the FTC, but at the Department of Justice as well. That was really helpful disclosure. You pull that out of John's book, it's not nearly as interesting a book as it is with it. And that was utterly voluntary, not compelled, not FOIA'd. It was just done because we ought to have a debate about this. That's a custom and norm worth keeping.
We can have more discussion, but I don't think Trinco has anything to do with the US Microsoft case. I don't think it changes at all the point I made in the paper about deception. It had nothing to do with the refusal to deal. Yes, the Trinco narrative is a troubling narrative for single firm cases. I also mentioned the allegation in the Epic versus Apple case, and there are some links in there to other articles that have been written about deception by monopolists and how we might treat those similarly as information impairment cases. I put it out there not as a finished idea, but I think it's something that can be worked with.
So first of all, thank you for resisting up to the end. I will be brief.